calling me names, so I just tried to stay out of his way.
And then after that?
Oh, when he started in on me pretty good, so I got uncomfortable and kind of scared, so I decided it'd be best for me to leave.
So you started walking home?
Right, I went outside and collected myself for a minute because I was pretty shaken up because Jones was so belligerent and angry, and then I started from home.
And you live north of the Red Apple Tavern on North Park Street, is that right?
Right, I live on the 3500 block.
Okay, so let the record reflect that the defendant was walking towards his house after he left the Red Apple Tavern. Now, were you afraid when you left the Red Apple Tavern of William Jones?
Yes.
And after you left, how long would you say it was before William Jones came out of the bar?
It seemed like he was right behind me. I didn't really get too far before I heard the bar door open.
And did he say anything to you?
He was calling me names, he was yelling, he said, you know, he was going to make me pay. It was pretty scary.
Sorry. And why didn't you just start running?
I'm not that quick of a guy. I didn't want to turn my back on him because he was pretty belligerent and drunk.
And then what happened?
Well, I started backing up and keeping my eye on him. He just like kept coming at me. He cut across the street to try to catch up with me.
So you have a larger man approaching you. He's closing the distance. Do you think it would be a bad idea to pull a gun out and just hold it, or to fire a warning shot?
I didn't. I thought.
Objection, Your Honor. Speculation.
The defendant has experience with in the situation, personal experience.
Overruled. Let me answer the question.
I was pretty scared. I didn't really know what to do. I didn't want to set him off. I thought he had his knife on him.
So he's coming at you. Now, did you see a knife, or did you just think he had a knife?
I thought he had a knife. I don't know.
Okay. And then, what happened after you shot him?
I was pretty scared. I'd never done anything like that. Didn't know what to do. Kind of stood there for a second.
Mm-hmm. And then you saw people come out of the bar, and they're...
Right, I just wanted to go home, so I started back, kept trying to walk to home, and then some of the guys from the bar caught up with me and walked me back to the bar.
What would you describe your state of mind when you started running?
I was in shock. I didn't really, it all happened so fast, and I was really scared. I thought the guy was going to kill me. I thought he had a knife. I was just shaken up. I could barely even talk. The guys from the bar tried to calm me down before the police came.
Thank you. No further questions.
Calling me names and yelling, and then as soon as he got really close, he just took a dive for me forward.
So you work at the Red Apple Tavern, and that would be south of the, at the A&P, which is south about a mile?
It's on the 2800 block.
Okay. And your apartment is up here?
On the 3500 block.
So you didn't go home because you wanted to go to the Red Apple Tavern before you went home?
Yeah, it was on my way home.
Objection. Speculation.
I believe you want this personal knowledge of this.
So why didn't you go home?
Well, it's the neighborhood from near the A&P is pretty sketchy, so Clark gets progressively better as you head towards my apartment, so I just stopped in at the bar.
No further questions.
Any requests?
May it please the court, counsel, members of the jury. Started this trial asking you to consider two questions. One, how does a man end up dead outside the bar with a gunshot wound that enters above his chest and then sits on his lower back? And two, why does a man who has nothing to gain shoot somebody outside his favorite place to hang out in front of people that all know him? And to the extent that those questions haven't been answered, it's because they haven't been proven, not beyond a reasonable doubt. No, we've all been exposed to this phrase through TV, movies, whatever. But I want you to think about it today like it's the first time you've ever heard it. It's a tough standard, and it's supposed to be. In fact, it's our legal standard's toughest standard. Our legal system's toughest standard. It's not what you think is probable. It's not what you highly suspect. It's not what you think is more likely than not. It's what has been proven beyond a reasonable doubt through the state's evidence. So when the state stands here and claims that they've carried that significant burden and proved an intentional and knowing murder, it's not supported by the evidence. The state presented 3 witnesses, one of whom was Officer Connor. She came in here to testify what happened after the shooting. Nothing she did or said is proof of anything. She's a fact witness. She's here to tell a story, and she gave us some insight into how she conducted that investigation. Now, I don't want to say Officer Connor did anything wrong. We have one patrolman, unassisted, responding to the scene of a fatal shooting. She pulls up, there's a crowd of witnesses, a crowd of potential witnesses. She doesn't interview, she interviews one of them. She talks to Fred Martin instead, who's way down here at the other end of the block. The shooting took place down there across from the Red Apple Tavern. She talks to Eddie Felton, who's inside the bar drinking with the victim, guy who works with the victim. Then she puts the handcuffs on Merle Roush, books him. No backups, no detectives, little if any crime scene investigation, not even a single photograph. I asked her the question point blank, she got dodgy. If there's a photograph of the crime scene, why isn't it in evidence? You won't have a photograph of the crime scene, and if any of the pictures that go back into evidence with you are helpful in making you make this determination, well then Officer Connor, maybe she did do her job. But in her haste, she failed to interview potentially crucial witnesses. She tags the evidence at the wrong address. Why? Because Officer Connor is not a murder detective. She's a patrol woman. She's in way over her head, and as a result, you don't get the benefit of a proper police investigation. And the second witness, Eddie Felton. Eddie Felton was exposed here today as inconsistent, biased, and untruthful. Eddie Felton lied under oath at the preliminary testimony. He said he hardly knew Jones, only from the Red Apple Tavern. He admits today that he worked with him on a dozen projects, knows him from work, drinks with him regularly, hardly know him, only from the tavern. He committed perjury at that preliminary hearing, and he committed perjury here. Eddie Felton would have stood up here and said anything to get a conviction for the death of his friend. Eddie Felton told Officer Connor that night, it was 2 to 3 minutes after Merle Roush left, that William Jones followed. Today, 5 minutes. He's sure of it. More than a year later, he's sure of it. I would suggest to you that none of his stories, nothing that comes out of his mouth has any credibility. Not a hint of credibility. He has no problem lying under oath. His motives are transparent. His friend is dead, and he wants Merle Roush, my client, to pay the price. And the third witness we have, Fred Martin. Did the best he could to testify what he saw. Didn't see much, if anything at all. We're talking a witness who's sitting on his porch, 130 feet away, under a bright overhead light, reading the newspaper. Middle of the night, there's no street lights within 100 feet in any direction. Tells us he hears some voices off in the distance, tries to see what's happening. Ladies and gentlemen, bring your own experiences into that jury room with you. You're under a bright overhead light, so you can read your fine print newspaper, and you're going to get up, look over 130 feet into the darkness, and tell me accurately how far people are apart? Fred Martin came in here, told us this street was 12 feet across. It's 50. Well, give or take 38 feet. I'm not sure it's reliable testimony, but it certainly is not proof beyond a reasonable doubt of anything. Not when a man's life hangs in the balance of the accuracy of what he saw. So after hearing all the state's evidence, what do we have other than doubt and speculation? What do we know about that night? We know Merle Roush left the bar that night. He was the bigger man. After William Jones persistently threatened and demanded money from him, we know he's walking towards his house. William Jones wasn't walking towards his house. We know that William Jones was a mountain of a man in comparison to Merle Roush. We know that William Jones had a reputation for hurting people, especially when he was drinking. We know Merle Roush has seen William Jones seriously hurting people in fights outside the Red Apple Tavern, and we know William Jones liked to carry a hunting knife. And we know Merle Roush knew him to carry a hunting knife. Merle Roush told the cops the same thing that night that he told you here today. No inconsistencies. And if Merle Roush believed his life was in danger, or believed he was about to be robbed when he fired that shot, he's not guilty. And that's exactly what's required under Maine state law to establish a self-defense justification. Now the judge gave you an instruction, and you'll take those instructions back with you. And he told, and under that, there are 4 things that if the state proves beyond a reasonable doubt, can negate Mr. Merle Roush's self-defense. 1, he provoked the attack. 2, he knew with certainty he could retreat with complete safety. 3, William Jones was not about to rob or use deadly force against him. And 4, Merle Roush knew he could defend himself without a gun. As far as provocation, the fact that Merle Roush started running after he shot William Jones is indicative of a complete lack of plan. The state is asking you to believe that Merle Roush planned this killing out for a week, at least a full day. And his big plan is to get in a fight inside a bar full of people who all know him, know his face, go outside, lay in wait, execute the victim, let everybody in the bar come out, get a good look of him holding the murder weapon, drop it on the ground, fingerprints on the murder weapon, take off running. Run where? Where is he going to run? He didn't know what to do because he never planned on killing anyone. And when he ran, it was because he panicked, not out of guilt, out of shock. So the facts don't support a premeditated attack, and the state certainly has not proven beyond a reasonable doubt that Merle Roush provoked this encounter. It was Merle Roush that was the bigger man. It was William Jones who was the aggressor. And Merle Roush testified he's not a fast runner. Couldn't get away with complete safety. We have a bar full of people 50 feet from Merle Roush. He has a 50-foot head start. He starts running and they catch him. I'd say he's not a fast runner is an understatement. He's running for his life, supposedly. He's not getting away from William Jones, a strapping, athletic man in his physical prime, charging towards him while he's walking backwards. And lastly, when Merle Roush fired that shot, he believed it was his only option. Only option if he didn't want to be found dead the next day on the side of Clark Street or beaten to a bloody pulp with his rent money gone. Merle Roush testified that William Jones had a knife, and he believed the best case scenario would be that he would be beaten and robbed of his well-earned money. And that as the judge instructed you, Merle Roush has no burden to prove anything. He walked into this courtroom with all presumptions of innocence. He's presumed to be innocent, and the law demands that he be found not guilty unless the state has proven through competent evidence, beyond all reasonable doubt, that he was acting in self-defense when he fired that shot. The defense asks that you not allow the state to convict a man of murder based on 2 unreliable witnesses, and instead find that Merle Roush was not only not guilty, but justified in his use of deadly force.